And now let me invite Sir Frank Berman to make concluding remarks. A few words about Frank. Sir Frank is now a barrister with the Essex court chambers here in London, and he has a very distinguished career. He worked for a number of years for the UK diplomatic service, and over the last 20 years he has been in practice in Essex chambers, specializing in international arbitration and advisory work on international law. He also served as an ad hoc judge in the International Court of Justice and various other proceedings. I just checked the UNCTAD ISDS navigator, and according to this website, Sir Frank sat as arbitrator in 16 proceedings, exit or essentially ISDS proceedings, not only exit proceedings, and also in 3 exit annulment proceedings. And Sir Frank is also a member of the ITF advisory board. Sir Frank, the floor is yours.
Thank you. Well, ladies and gentlemen, my task is to bring these proceedings to a close, and it's a very pleasant task indeed, because I hope that you've all found them as absorbing and valuable as I have. Evidence. I, as an international lawyer from an avowedly common law background, I had developed over the years the approach that something like 75% of all international disputes were fact, and the remaining 25% were law. That, as I say, reflects also my own common law background. I've changed my view since I came to practice and since I became involved in the field of international arbitration. My view is now that far more of it is fact. Far, far more. And when I look at international investment disputes, I would say the overwhelming proportion of all disputes is fact. A small residue is law. And most of what masquerades as law isn't actually law at all. It is the application of legal rules or principles to a set of established facts. And if all of that is true, it means that what we've been talking about today as evidence in international investment disputes is of absolutely critical importance. So my compliments, my personal compliments to BICL, to the ITF, of which I do sit on the advisory board. And it is suitable, isn't it? It's appropriate that BICL should have taken today's initiative, because BICL has been well ahead in this field. I think back to that groundbreaking study, which was published by Yarrick, I think 5 years ago, on evidence before the International Court of Justice, a BICL production, as the outcome of a lengthy, careful study, and which was intended to be the springboard for more work and systemic work in this area of evidence in international dispute settlement. So my compliments to you and to the participants, and I hope there's going to be much more of this coming out under the redoubtable brand of the British Institute of International and Comparative Law. What I particularly enjoyed this yesterday and today was this. Law isn't a science, it's a skill, it's an art, isn't it? Despite that misleading term of legal science, which is sometimes used by our continental colleagues, law is a practitioner's art. And there are not many things that are more pleasant than hearing skilled craftspeople talk about the exercise of their own craft. And that, I think, is what I've enjoyed most of all over the last 2 days. And I found it immensely valuable as a practical, empirical approach to what is the key problem in international investment arbitration, that of evidence. I was struck too by the fact that because of the way in which the panels are being constructed, what we were hearing about was the skilled professionals who put the cases together, present them to tribunals, or act as experts in that process. We didn't hear actually very much from the tribunal side. We heard a bit in one or two of the telling remarks by Daniel Bethlehem at the beginning. Mark Cantor has reminded us from time to time that he's an arbitrator too. And we've had the odd little remark by myself and Vaughan Lowe. And I began to wonder a little bit why. It's fine, isn't it, for the practitioners to say, this is what you ought to be doing in presenting important issues to a tribunal. But why haven't we had the tribunals telling the practitioners, this is what you ought to be doing to be useful to us? I suppose there are inhibiting factors. One of the obvious inhibiting factors, which I found weighing on my shoulders too, when I happened to notice yesterday that lead counsel in a heavy case, which is still before me, was amongst your participants, was that anything you say about evidentiary issues might indeed be taken down as an indicator by counsel in a case before you, that you have a prejudice, or at least a prejudgment about evidentiary issues that are going to be of importance in the pending case. But all the same, and I'll come back to this at the end of my brief remarks, I think what we're talking about is an essentially, as I say, a craftsperson's task, a pragmatic one. I wonder about the place of general rules and theory in this area. I notice that say what you like, theory tends to creep in like a thief in the night through some sort of open door or window. And I did hear at the beginning discussion about a supposed duty, which some people say rests on a tribunal to pursue the truth. And that's the point at which I began to feel a little bit uneasy and uncomfortable, not because I don't believe in there being a truth, I don't believe in truth or honesty. Of course I do, and anybody sitting as I do in the United Kingdom at the moment, taking an interest in politics, will have had the idea of truthfulness and honesty very much to the forefront of their minds. Yes, indeed, but what do we have in the case of international disputes, particularly investment disputes? These are not criminal trials in which there is usually, at least within the caricature picture in the ordinary person's mind, a specific event. Either X did it or X didn't do it, and that is a matter for proof behind a court with which, following which there are serious consequences. What we have in the case of investment disputes is something different. There is a complex series of events. Certainly there are hard facts on the ground. But what the tribunal is confronted with is two stories. There's the claimant's story, and there is the respondent's story. And both of those stories build upon the facts of the case in order to explain them, in order to make them coherent, and in order to propose that conclusions should be drawn based upon that view of the facts in the case. And that, I think, is what investment tribunals find themselves doing. They're confronted with two stories. They have to assess those stories. And the stories are, of course, stories based upon a factual account of events. One side or the other makes certain facts into more significant, carrying greater weight than the other. The other party may attempt to undermine what appears to be a fact and show it as being something different. But they are two stories, and at the end, and they're not, of course, the only two stories. A tribunal is under no obligation to accept wholesale the story from one side or the story from the other, but to arrive at its own assessment, overall assessment of what happened in a particular case and what conclusions follow from that. So we are, I think, dealing with something which is far more a matter of judgment, not surprisingly, and then a matter of scientific proof. Which leads to all kinds of other really interesting speculations in one's mind, which I think continue to exercise the mind, as our practitioners over the last 2 days have shown us. I'm not going to say much about particular issues of evidence or proof, other perhaps than 2 comments. One is that I noticed also, and with great respect to the panelists who raised the point, this issue of the burden of proof and the shifting burden of proof. And with all respect to the eloquence with which that has been referred to in this proceeding, I find my skepticism of the idea of a shifting burden of proof remaining virtually untouched, as strong as ever. We do have things that need to be proved by a party in order for that party to sustain its case. And it doesn't matter whether the party is the claimant advancing a claim or whether it is respondent advancing a defense. It will always remain the case that the claimant advancing a claim has to prove its claim to the satisfaction of the tribunal, or the respondent advancing a defense or undermining the claim will have to prove its defense, or will have to show that the claim is not sound, is not solid. And that is going to lead, of course, to numerous questions of evidence in which the good, solid international proposition, principle that he who alleges must prove will be the guideline to which everyone cleaves. And within the scope of that, I don't think there's much room for confusing the picture by suggesting burden of proof is here, and then it goes there, and then it becomes there, and then it ends up somewhere else. It's a solid question of establishing your case. And what does establishing your case mean? It means surely showing to a tribunal consisting of human beings, at least I think so. Most of the arbitrators I've sat with are more or less human beings. A tribunal consisting of human beings, that they are more convinced that one account of the set of demonstrated facts is to be preferred over the other account, and how far it needs to be preferred, of course, is a matter very dependent upon the circumstances. And that, I think, is really the be-all and end-all of the story of the role that evidence plays in the international dispute settlement process. The only other comment I make is that, of course, we're talking about proof in various different contexts. And I was very struck by this, particularly when we came to that fascinating final panel a few moments ago. Previous panels have been talking about proving facts, and this panel had been talking about proving damages. And of course, damages are different from facts, aren't they? They have to be different from facts. The damage flowing from a breach that has been found of an international obligation is not a fact in the same way as whether or not a contract was signed or was tainted by forgery or corruption. It is an assessment that has to be arrived at by our same collection of human beings, and of course different things go into making that kind of assessment. There is also, I think, and I make this as my final comment on that issue, too much of an outside assumption that an international investment dispute decided in favor of a claimant leads to an award of damages. That is not necessarily the case. It depends, doesn't it, upon the relief which the claimant has asked the tribunal to give. And the kind of pleadings I see in front of me usually involve a whole raft of different measures of relief for which a claimant is asking. But even that issue of damages falling within the spectrum of relief is a matter of relief, and relief, we all know, is something which depends very heavily upon the discretionary assessment of the tribunal as to what is appropriate in the particular case. And so it must be also, I think, with damages. And it's not, I think, it's not accidental that the leading instruments which have been referred to, the ICSID arbitration rules, the UNCITRAL rules, all of them say no more than that. The tribunal is given a very wide discretion in the way it deals with and evaluates evidence before it. But is that just a confession of defeat on the part of the arbitrators? Should there be a law of evidence which is arbitrator developed so as to give guidance to the parties? And then I think is at the end of the day, the very interesting question. I'm rather against the idea of having a law of evidence. It will follow the same path as national systems which have laws of evidence will become immensely complicated, very difficult, have more in it for parties to stumble over than to be able to use. But I do come back at the end of the day, and this is my last final remark, on what the duty of a tribunal is. The characteristic of judicial settlement, international, domestic, anywhere else, is not that you get a decision, but that you get a thought out, deliberated, carefully arrived at conclusion by way of decision. And most important of all, you get a reasoned decision. A decision, the groundwork of which is made public. It may be made generally public, and nowadays usually is, or it may be only be made public to the parties, as in some cases, but it's a reasoned decision. And this leads me to my final feeling, following this very interesting discussion, that tribunals should take an enormous amount of care to explain, when they're dealing with the evidence before them, to explain what their conclusions are and why they have reached those particular conclusions, as much in the field of evidence as in any other part of the award which they finally deliver. That, I hope, is what good tribunals do, and they do it in a way which the parties can understand. But that ought to be the beacon at the end of the road when tribunals set out to complete their work. With that, my final compliments to you, Jarek, and to the BICL ITF, and my good wishes to everyone who's had the good fortune to be part of this discussion.
Thank you very much, Sir Frank, for your observations and sharing your wisdom and experience with us. On this note, I would like also to thank all other speakers and chairs who participated in this event. I would also like to thank Liam and Bradley, who stayed in the background and made this event so smooth, and HKA for their sponsorship. I hope to see many of you on the 14th of May at our events dealing with damages, cost, and duration of investment treaty arbitration. And later this year, we hope to launch at least 2 more studies, one dealing with sovereign wealth funds and international dispute resolution, another one dealing with investment arbitration of banking and finance sector disputes. Our big ITF conference the second big ITF conference of the year will take place in autumn, and we will look at issues of time limitation in the context of investor-state disputes. If you are an ITF member and if you would like to organize an event or want to discuss a project, please let me know. And I would also like to draw your attention to other parts of BICL, not only to ITF and its online course on ISDS, but also to other online programs, for example, Public International Law in Practice, which we regularly run, and which is quite popular with law firms and with government officials. We will make a video recording of this session available in the members only section of the ITF website. And let me stop here, and I hope you have not less enjoyable plans for the rest of the day and for this weekend. Thank you very much for your attention and hope to see you soon again.